Well, that puts you and your children at risk. His charge was actually attempted murder in 2015. And that time he was an Indiana resident. I don't remember exactly the result of that. At any rate, Meg, do you and Ms. Long wish to consult at this point, or she just knows that how to get a hold of you to discuss it further?
I'll speak with her for a minute, if I may, Judge.
All right. Ms. Cousineau, Mr. Butchart, will continue this to Tuesday, 21st at 8:50 in the morning. And Ms. Long, I'll put you and Meg in the breakout room. You guys can discuss it further.
And Judge, before you do that, just so I can confirm and make sure my plans are appropriate, will that next date be considered a trial date for the court, or is that a continued pre-trial
Well, we
date?
have 10 minutes, so I'm not sure we'll be having a trial. We'll see
Understood.
where we are. If we need a trial, you know, all that stuff about how many days his car's in the parking lot and who sees him and the other allegations, we'd have to probably block out several hours of time for that. So
Okay.
we've got only 10 minutes on that morning, and then we'll see where we go.
That works, Judge.
But
Thank you.
we are encountering the proverbial rock in the hard place. She doesn't want to move and they don't want her there, and we'll see. All right. Ms. Long, you join the breakout room, and Meg, you can, and I'll continue. Hire a lawyer. If you can't afford an attorney, you can ask to see if legal aid would represent you, or you could seek other legal representation. We don't have court-appointed attorneys in civil matters, at least not yet. You have a right to have the case heard here in St. Joseph County, where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first appearance, or make the demand in writing within 5 days using the jury demand form, and be prepared to pay the $50 jury demand fee. You may be able to reach an agreement with your landlord, in this case it's the bank with the plaintiff, by going through mediation. That has never happened, but it might one day. If both parties are interested, the court can help set it up. Also, you may be able to reach an agreement with the landlord or with the bank that you agree to move by a certain date and time, and they would agree to dismiss it. That would be called a conditional order of dismissal. If the bank is agreeable to that, they or the court could prepare the form. So your case is set for 9:40, I think, which is about 4 minutes from now. So let's wait for the bank. Mr. McLean, stick with me. When we finish this case, I'm going to release you. Is Lucille Bloom is no longer living there?
No.
Who was she?
The person we thought we bought the house from?
Was that on a land contract?
Yes.
All right. Jessica Long is here from a universe far away, it appears. Good morning, Ms. Long. You're our next coming case at 9:50 from Village Manor. So
Yep, good morning.
stick with, we've got a couple other cases to address.
Okay.
The plaintiff in this case, Fifth Third Bank, is represented by a very large law firm, Trott and Trott. And they have a number of attorneys that are in their firm, but they're very often required to be in court all over the state. So they make log in at like 1 minute. It's a showtime. I guess I could use our dead time to tell Miss Long about her rights. Miss Long, you're a tenant in a landlord-tenant proceeding, and your landlord wants you to move. They filed a termination of tenancy action alleging lease violations, including another unauthorized tenant. They served a notice to quit on you back in April, and they're asking you to move and to leave your tenancy. In such a case, you have a right to hire a lawyer. If you can't afford an attorney, you could see if legal aid would be willing to represent you. Attorney from legal aid is here with us this morning. We value that service so that she may be available at least for a consultation. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or file a written demand within 5 days, and either way, be prepared to pay the $50 jury demand fee unless the judge waives the fee for your inability to pay it. If both parties are interested, the court can set the matter up for mediation. So far, that's not ever happened, but maybe it will one day. Or you may be able to reach an agreement with the landlord by where you would agree to move by a certain date or some other conditions. They could dismiss the case with what's called a conditional order of dismissal. So we'll get to your case here in a couple minutes, but those are your rights. Mr. McLean, I'm going to go ahead and release you. Plaintiff failed to appear, and I'll allow the case to go no progress after 30 days. All right, Mr. McLean and son, enjoy this summer day. Fort Wayne, I guess, is as good as any place to be. But apparently you've moved out, you've vacated, you turned in the keys, there is no lease, there's no security deposit. They don't take any action within 30 days. I'm simply going to allow this case to be dismissed. Good luck, sir.
Good, thank you.
All right, I think he had some technical assistance from his son, but he was here right on time. Good morning, Ms. Albu.
Good morning, Your Honor.
Our defendant, Davida Alderson, is here in our case. I've already advised her of her rights. The case at hand is Fifth Third Bank versus Lucille Bloom, Davida Alderson, Joseph Alderson, or all occupants. Lucille Bloom is not present. She was served by substituted service. Mr. Alderson's at work. From what I gathered from the defendant, they were buying the property on a land contract from Lucille Bloom. Doesn't appear Ms. Bloom was making her payments to the bank, and this matter was subject to a foreclosure. This house is at 501 Wood Street in Three Rivers. And Miss Alderson, that's not 501 Wood Street. You've got a background there. As a kid, I spent many days at 501 Wood Street. My best friend lived there, and it was a nice house. Anyway, that was a long time ago, but I'm very familiar with that address. Ms. Albu, this appears to be pretty straightforward. There was a foreclosure sale last November. The property's not been redeemed. It sounds like the Aldersons may be at the back end of a bad deal with a land contract vendor. Nonetheless, the bank has foreclosed on the house. Miss Alderson, what's your plan?
We are working on buying a house. I have about $1,400 worth of debt that I have to take care of. I'm working with somebody at the bank now to try to get everything situated so we can.
All right, well, you're trying to buy this house?
No, we're trying to buy another house.
Okay, now, that's great. The problem is they want you to move out of this house.
Yes.
Now, here's the deal. The law says I have to adjourn this matter at least 7 days for a couple reasons. One, we don't have service on Ms. Bloom, although we probably have a second mailing. Anyway, that's what the law requires. Then you'd get an additional 10 days from that day to move out. I'm going to be gone for a few days, and I've squeezed in a landlord-tenant day on Tuesday, July 21st in the morning. That's an odd time for our landlord-tenant docket, but I do this every year. So I would adjourn this, Ms. Albu, to Tuesday, the 21st of July at 10:45.
All right. Thank you, Your Honor.
That would then give you until July 31st to move out. You'd have 10 days from that day to vacate or be subject to being evicted. Do you believe you can get out of there by the end of the month?
I don't. When attorneys first contacted us, they told us they would give us 90 days before they even started this hearing. And then we turned in our purchase agreement, and they said you have 10 days. I have 5 kids, and we're trying to buy a house to get out of here. I have $1,400 worth of debt to pay off before I can get a house.
All right, well, let's slow down a little bit. There's an intermediary, this Bloom. The house was posted and there was a notice of a sheriff's sale last November. The buyer has 180 days to redeem it. So that's November 13th, December, January, February, March, April, May, June. 180 days was up in June. And they're asking to foreclose. Now, I don't know when you got notice, but this didn't sneak up and bite them in the ankle. They had, as a practical matter, no payments have probably been made on this house for several years. So the bank wants to foreclose and they want to clean it up, repackage it, and resell it. They can agree to give you more time, but by the letter of the law, this is the process that's followed in foreclosure actions. And the cold hard truth is the sheriff could come on August 1st and put all your stuff out in the street, whether you're ready to move or not. And Ms. Albu, do you have any discretion in this matter?
Your Honor, I could opt to 30 days.
All right, well, they would agree to 30 days, which would be to August 11, August 10. But anyway, the wolf is at the door and the clock is ticking to midnight. So I'm going to leave this on for next, the 21st, and we'll see where we go. They would give you additional 10 days after that, which would be August 10th. I don't know when you got notice of this, but it was posted on the house. There were some other things. I think you must have known as of November they were trying to foreclose on it. And as a practical matter, I hope you stop making your payments to Ms. Bloom. You may have been making payments to her. She wasn't making payments to the bank. So right now you're making no payment, which is good to help you get your next house. But the bank's not going to wait around till October until you get your other debt paid off and work out your other house. So right now we're just going to leave this on for July 21st at 10:45. Meg, I don't know that there's anything here. I think the next defendant may need your services. in this termination case. Anyway, Ms. Alderson, I gave you the information for legal aid. But I don't know that you have any defense. You're the person that was buying the house wasn't making the payments. And you can't really alter that. You're just gonna ask for their indulgence to get some extra time, and they do have some discretion. So Ms. Albu, maybe you can see if you've got any additional discretion when we convene again, July 21st at 10:45. Ms. Alderson, you did a good job. You logged in early. I could hear you and see you. It'll be by Zoom again, Tuesday, July 21st at 10:45.
Thank you, Your Honor.
All right. Do you have any questions? Where is Lucille Bloom?
I don't know. I used to have an address for her, but it's known everything has been getting returned.
All right. Well, you have the benefit of not making any payment right now. I don't know how long you've been living without making a payment, but that's something. But obviously, this can't go on. So I'll see you on July 21st at 10:45. We'll see where we are at that point.
And Judge, I'm certainly happy to consult with anyone that wants to talk to us, and if we can't help them, we can let them know. But just,
Ms. Alderson, do you wish to wait around a little bit? You may be able to consult with the legal aid attorney.
Sure.
All right, stick with us here. Our Village Manor case is next. Ms. Cousineau is here. Ms. Long is here. Ms. Albu, you're good to go.
Thank you, Judge. Have a good day.
Thank you. I'm working on it. Good morning, Ms. Cousineau.
Good morning.
I've advised the defendant of her rights while we had some dead time here. Law firm to join us. We have a couple of civil matters at 10, and then we have back to landlord tenant at 10:30, and then we have Centerville Mobile Home Park and Wired at 11. The district court liaison to the Judicial Tenure Commission, I think I mentioned this, told us last year that one of the #1 complaints they had about judges to the Judicial Tenure Commission was they weren't advising tenants of their rights. So that is a little cumbersome, but it only takes a minute or two to go through it with each defendant. Some judges do it, as you know, by video at the beginning, or some more routine thing. We just do it each time.
I think I'm glad to report that every judge that I'm aware of in legal aid of West Michigan Kalamazoo's jurisdiction is very routine about it. I mean, there's one judge in Kalamazoo who does a much more abridged version, but we haven't been concerned about it. I'll say that.
Mr. Taub, would you join us, please? Oh, he's not here on this.
I'm
Mr.
here.
Taub,
Hi.
GC says we're waiting for an attorney in a landlord-tenant case. Which one of the 10 o'clocks have you got?
Are you talking to me, Your Honor?
Yes, sir.
I have Orbit Leasing Inc. versus Trevor Arnold. I represent Arnold.
All right. Yes, you've asked for mediation. All right. Well, stick with us. You can go ahead and shut your camera off. We're waiting for an attorney so we can do our landlord-tenant case. So a little bit back. You're in the right spot.
Okay. Thank you.
I would put you in the breakout room with Miss Alderson. But about the time I do that, someone will show up for the plaintiff. Miss Long is a termination of tenancy case with what may be some issues.
Yeah, I think it's up to Miss Alderson if she wants to wait. I'm happy to talk to her, but she certainly doesn't have to wait.
Well, I think she said she's willing to wait, so. All right, I don't like this dead time. We've got a bunch of cases starting in 6 minutes and we're burning daylight. All right, I'm gonna put you in a breakout room with Miss Alderson. Miss Alderson, when you see the button that says join, you join. And you can speak with Attorney Bauer from Legal Aid. Miss Long, you stay with me.
Can Murphy's Law be summoned like that, Judge?
Yes, that's how it works. They're not here. Their people are ready on my 10 o'clock, so I'm going to go to the 10 o'clock. Miss Kuzno, you stay with me too. All right, I've got Mr. Chisholm here, so I can address the Orbit leasing case. Good morning, Mr. Peters.
Morning.
You got your Zoom going. Good for you.
Yes, I do.
All right, you're in the right place.
Although your volume here on my end is quite low.
Well, maybe I need to speak up. All right, good morning, Mr. Chisholm.
Good morning, Your Honor.
Good morning, Mr. Butchart.
Good morning, Your Honor.
We've been waiting for you to show up, and so we skipped ahead, so stick with me for a minute. We're gonna
Yeah,
take
my
up another.
apologies, Judge. I had another matter with you and I had them both scheduled at the same time in my head. My apologies.
All right, well, I've got multiple other things going on here, so I'm gonna take up this matter. Our legal aid attorney is talking with another client. Your apartment manager is here and your defendant is here. And I advised her of her rights, but we got tired of dead air, so we went on to something else.
Understood,
All right,
Judge.
let me call this case, Orbit Leasing versus Trevor Arnold. File number is 26102GC. Mr. Jeremy Chisholm is here for the plaintiff. Mr. Chisholm, I haven't seen you in a while. Good morning, sir.
Good morning, Your Honor.
Mr. Adam Taub is here for the defendant.
Good morning, Your Honor.
This is a claim for at least district court standards, a substantial amount of money, $18,041.13 regarding an automobile transaction. Mr. Taub has filed a motion to compel arbitration in this case under some of the clauses in the agreement. Mr. Chisholm, have you and Mr. Taub had an opportunity to discuss this at all?
We haven't, Judge, although Mr. Taub and I have worked together in the past, and I expect that that we'll be able to work out something. In this case, we do have a pretty good history, I think, of working these things out in the past.
I agree. I basically just I'm looking at the arbitration clause, and There is, as the court noted, there is in the complaint a substantial amount of money, nothing to sneeze at, involved here, but there's also potential counterclaims because this involves a car and subprime leasing, et cetera. And without going into any of those, we think the right place to do it is to adjudicate all those other issues, including ones against other parties, to this transaction is in arbitration.
Mr. Chisholm, what's your position regarding the motion?
I guess, Judge, to be honest with you, I wasn't aware of the motion for arbitration. I did not realize that it was up today. I had this on my calendar as a pretrial. As the court might be aware, and I think Mr. Taub might be aware, I am the corporate counsel for Orbit Leasing, and to say that they have me spread thin is spread out over 3 different states, and so looking at these things on a day-to-day basis, sometimes I'll miss something like that. But my general position on arbitration is that it's a waste of money in all but extraordinarily complex cases or very, very high-profile cases. I think we all understand that arbitration provisions are put into contracts. I think. As kind of boilerplate stuff usually to avoid class action lawsuits is my belief with it, and any other invocation of it doesn't make any sense to me. I think this court is as good a trier of fact as anybody. There is a Michigan court rule specifically that it addresses the idea of needless increases in expense to litigation, which I usually feel arbitration is. I don't. Like I said, Mr. Taub and I have had a great working relationship. I don't necessarily understand all the backstory with this from the plaintiff's perspective. This was just a car that was totaled without insurance and leaving a very high balance, definitely. But I am not aware of any other circumstances that would make this better heard in arbitration than it is in a district court setting. I certainly feel like the district court setting is obviously more economical for both parties, and so for that reason I would oppose it. But again, I think most importantly, I think I would like a chance to just speak with Mr. Taub and see if we can't get this thing worked out. I did reach out to your office last night, Adam, and I realized kind of last minute, but
here's a thought. I'm inclined to grant the motion, but it goes down a whole different rabbit hole once I put it in arbitration. You're right, it's in there as boilerplate, but it is in there. And most defendants are not astute enough to recognize it when they have competent counsel. What I would propose is maybe we adjourn this about 60 days, let you guys see if you can get close to the finish line, and then review it. And if you can come to a resolution, great. If we can, I can always order it at that time. Mr. Taub, is that acceptable to you?
Yeah, I have no problem. I was going to say we can make this a lot simpler. And if Mr. Chisholm represents that he didn't get a copy of my motion, then I'll just resend it to him and give him time to answer. 60 days is great.
That sounds good to me, and I certainly don't want to in any way imply that Mr. Taub didn't send me the motion. I want to make that clear. I'm sure that Orbit Leasing has it somewhere. My guess is that the eyes that are supposed to kind of recognize these things and raise them up the chain and to get them to me if there's something unusual, just didn't recognize it and didn't put it before me. But I'm assuming that's what happened here. I'm assuming we have to give it somewhere, but if it's not too much trouble, Adam, if you could just email it to me, that'd be great. And I'd really appreciate it.
Yep. I will.
All right. I'm going to continue the motion and the pretrial to Monday morning, September 14th at 9 a.m. And that'll give you guys some time to discuss it, see if you can get somewhere. If not, Mr. Chisholm, I'm inclined to grant his motion. But we'll see where we go. We're not
Okay.
losing by taking up 60 days.
Sounds good. I appreciate that. And thank you.
All right. Thank you, gentlemen. Both have a good morning.
Judge,
And
Judge, before you say goodbye to us, is there any way we could do it on the 7th of September? I have an in-person.
yeah, let's take a look.
presentation.
I went to the 7th, but it's blocked for some reason. Let's see what this is. Blocking out the calendar for Monday, September 7th.
That's Labor Day.
Oh, that's right.
okay.
Yeah, that's why it's blocked. How about the 21st?
You know what? The both those dates are yeah, both those, the 21st and the 14th are bad for me.
Well, how about the September 11th?
That's probably going to be, yeah, that's fine. That works for me.
All right, September 11th at 10 a.m.
Great.
All right, thank you both. It is Friday, it's Michigan, it's sunny, it's warm. We all wish we were somewhere else, but we'll finish up today.
Time to head to the beach.
All right, that's
Okay.
it. All right,
Take
thank
care.
you both.
Thank you,
Thanks,
gentlemen.
Judge. Thanks,
Appreciate it.
Jeremy.
Thank
I'll
you.
send you that. Bye-bye.
Appreciate it. Thank you.
All right, yes? Oh, that one, okay. All right, you can have.
First docket ready. Yeah. Most of it done.
All right. Mr. Peters and Mr. Sims, stick with me. We're gonna go, Mr. Groen, are you on, Citibank?
That's the one, Your Honor.
All right, thank you. Stick with me. We got a little bit behind. Let's take up Village Manor versus Jessica Long. Mr. Butchart, would you join us, please?
Yes, Judge.
We didn't assume you were out goofing off. I assumed you were stuck in another court. And so we just moved on to something else.
Somewhere between the two, Judge. I was assembling a motion in a different court, all the while thinking I only had 10:30s before you today. So again, my apology.
All right, well, let's call this case. This is file 261258 LT. It's entitled Village Manor versus Jessica Long. Ms. Long is present. Also, the manager, Ms. Cousineau, is here, and Meg Bauer from Legal Aid. This has been filed as a termination of tenancy. It was filed back in April. I've advised Ms. Long of her rights as a tenant. The allegations are several, but one of them is that she has an unoccupied tenant in the premises. And then they list a number of other lease violations in a lengthy letter dated April 24th. Mr. Butchart, is that still the plaintiff's position? They want the defendant to move?
That's correct, Judge.
Ms. Long, what's your position? You need to unmute your mic.
So, I am a single mother of 6 kids, and I've tried to find places, but nobody around here has income based. I don't have like decent jobs. I mean, I had 2 jobs. I'm down to 1. I mean, I tried. I've talked to Lori. And
All right, Ms. Cousineau, who is the alleged unauthorized tenant?
I believe it's her kid's dad, Vladimir.
And he's not on the lease?
No, he is not.
he doesn't live here.
Well, we'll see. Now, there's other allegations in the notice to quit. And these are hard. How much is your rent?
I'm not sure because I was paying 116 and then it went up and down. So I'm not sure at this point because they haven't let me pay rent for 3 months.
Yes. Once they file a termination of tenancy, they can no longer accept rent. But sometimes instead of treating it like a valuable treasure, they treat
money
it like
orders.
a shoe. But they allege a number of incidents, many of which are from your unauthorized tenant. Alleged tenant. On March 25th, you received a written notice of lease violation because you have an unauthorized occupant in your unit who has threatened other individuals on the premises. Your unauthorized occupant called another person a name, threatened to kill another person, yelled that he wanted blood, and other things. So there are a number of allegations in it. So they want you to move out.
I talked to Lori about that situation. Once again, he's not an unauthorized occupant. He does not live here, but he watches my kids for me, especially when I work. It makes it easier for me, and I don't have to pay a babysitter or try to find one that goes around my hours because my hours vary. So on that day, I had worked the day before. I had worked.
All right. Well, don't say any more about it at this point. But there's a fine line between. We've had this argument for dozens of times where they've got child's parent living in the home and he's not on the lease, and they've calculated how many days the car is there in the parking lot. It's there every morning, 6 days a week, that sort of thing. I don't know if we've got that kind of evidence here. They contend he's living there and he's a annoyance and nuisance to the other tenants, which puts you and your 6 kids in a precarious position. The law requires that I continue this matter at least 7 days. I'm absolutely fill up to the brim on the 21st of July, but that's where we're going to put this.
And I have been talking with Meg. We have been in contact.
Okay. I'm going to set this for 8:50 on July 21st.
Okay.
I'm sorry, Judge, was that 815 or 850?
850.
Thank you.
That's an odd time for us to do landlord-tenant cases on a Tuesday morning, but I take a vacation every summer and then I come in on that Tuesday and do landlord-tenant in the morning and sobriety court in the afternoon. So Ms. Long, you've been talking with Ms. Power. I asked her to be sure to be here for this, but I don't know the answer to this. And you're correct. There is not enough subsidized housing to be found. Your rent's $116. You're not going to find anything comparable anywhere. If they get what they ask for, you and your kids will be homeless. And you can blame the children's father, I guess, for that. And like I said, sometimes it's hard to distinguish between what is a tenancy and what is someone offering childcare. Can't tell, but they contend he lives there. And
Judge, may I just put something on the record briefly?
yeah.
Ms. Long has had a consultation with me. I have obviously not filed an appearance. Ms. Long and I don't have a retainer agreement at this time. So, Ms. Long, you're responsible for all court dates and deadlines unless and until that happens. But I can't do anything more to help without a copy of the court paperwork. So,
What's Vladimir's last name?
Hofield.
Caulfield?
Hofield.
I haven't had contact with him in a long time. He had a very serious charge 10 years ago.
He's
I don't have any.
free from everything. He's not been,
Yes. Anyway, I don't have anything that shows an address for him.
because he don't have a legitimate, he pretty much couched, as you can say.
With our next matter.
Thank you, Judge.
Yeah.
Mr. Sims,
Yes, good morning, Your Honor.
morning, sir. You're here on a case
TD.
that they took off TD. They took it off my docket.
Oh, that's awesome. Okay, well, good. I was just making sure. We have it resolved. I'm just waiting for the consent judgment to get back signed.
I saw it was adjourned by the plaintiff, and I apologize. You've been in the waiting room for 20
Nope, no
minutes or
problem.
so. But got to watch a little St. Joe County landlord-tenant court.
Well,
Anyway, that matter.
I enjoyed it. I'll just say
Thank
that. And then, and next, man, way better than being there.
Well, let me
All
show
right.
you my court here. We're
Yeah,
in
it
the
looks nice.
historic 1899 circuit courtroom
That's
that we're
great.
using while our court is being renovated. So that's what you're
Awesome.
missing out on. But at any rate, that matter is adjourned. You're working on a settlement, and have a good rest of the morning.
All right, you too. Good to see you.
Thank you. Okay. All right, Mr. Groen, thank you for your patience. All right, Mr. John Peters is here. The file number in this matter is 242164 GC. It's entitled Citibank versus John Peters. Mr. Brian Groen is here on behalf of the plaintiff. Mr. Peters, I'm glad you were able to get a Zoom connection here. Well, let's discuss this. This is a claim for $480.42 plus cost, interest, and attorney fees. The plaintiff, Citibank, is attempting to garnish Mr. Peters' funds. In fact, I think they did seize his funds at Century Bank and Trust, which left him penniless. Mr. Peters, I don't think I'm disclosing anything. He is working with the court on a probation, and he's doing very well on that probation, by the way. But we learned of that sort of as an aside. All of a sudden he had no money because the garnishment hit. So he filed an objection. Mr. Peters, what's the nature of your objection?
I honestly didn't know anything about it. I never received anything in the mail that I seen. Didn't know this was happening or coming.
Well, they don't tell you, hey, we're going to garnish your bank account in 2 weeks. Everybody would take all the money out of the bank. So no, they don't say, hey, this is coming. They get a judgment. They attempt to collect on the judgment. And
well, as far as that too, I do not recall receiving anything for the court date, which I believe was in June of last year, possibly.
yeah, let's talk about that. This was a default.
Yes.
The summons and complaint was filed in December of 2024, asking for, it was a Home Depot credit card, And they were suing you for $3,480. So they filed it with the court. They had to serve you, oh boy, proof of services in here 15 times. Really? They sent it to you by mail at 18100 M86. Michelle, I don't know why the proof of service is in here 10 times. I think they sent it. They sent it in August. They sent it in July. Wow. They sent it again in August. What the heck? They sent it on the 17th of September. What kind of process server this is? They sent it on the 19th of August. Once a day, they're mailing you a proof of service. 23rd of July. Looking for something that actually is a service other than first class mail. I don't know if I've ever seen this. They sent out on the 28th of August, again to the same address. 22nd of August. Then they filed a proof of service that says they posted it at that address and they sent it by first class mail. And then they sent it again. So we had an alternate service. They couldn't find you. They sent 12 letters to 18001 M86. They didn't come back and you didn't respond. So they got an order for alternative service that I signed in February of 2025. So they posted it at your house and mailed it again. So it was filed by alternative service. You didn't answer it. Then they got a second summons. Anyway, it was served by posting and by multiple mailings. And then a default judgment entered in May of 2025, indicating that the judgment was entered by default in the amount of $3,705. So, Mr. Groen, what's your position here?
Your Honor, based on his objection, there was no box even checked. So it's kind of hard to prepare for an objection when you don't know what the basis of the objection is. And based on what I've heard this morning, there really is no valid objection to this bank garnishment. So I would ask the court just to deny the objection and let the bank release the funds to us. We have received no payments since the judgment's been entered. These would be the first funds applied to the outstanding judgment balance.
Mr. Peters, in
Yes.
theory, you have to have a reason why you object other than, hey, I object. They took all my money. This happens a lot. Now, right now, you don't have any source of income.
Correct.
At least not anything. The problem is you need your bank account to live. So anything you get that you put in the bank, they're gonna seize. So let's say you do some work for somebody and build a porch or a deck and they pay you $2,000. You put it in the bank, they're gonna seize it. That's not sustainable, at least for you. If
No.
you got disability and you put it in the bank, they can't seize that.
Correct.
But anything else that goes in there, they can take. How much was taken?
1,000 some odd.
One,
I don't know.
I have the amount, the garnishee disclosure, looks like it's $1,096.79.
I guess I could have looked it up myself, but thank you, it's right here.
That's okay. I actually had that one right in front of me.
All right. So unfortunately, Mr. Peters, they're entitled to take that, but I don't want to just leave this garnishment in place, or every time you put any money in there, they're going to seize it. So we need to set up some sort of a payment plan, where you make payments which would forestall them from doing these garnishments. Can you, now, Mr. Groen, Mr. Peters is working on several different things. He's trying to get his identification squared away, to get, it's a long story, but he lost his identification. And so he has a difficult time doing anything. He also owes money to the court and has expenses for being on the probation. He is waiting for a potential disability settlement. So he's not in the current position to make much of a payment. But I don't want to just leave this garnishment open-ended because he can't live that way. Anything that he puts in the bank to pay out a bill will be seized.
I have a suggestion then, Your Honor. Based on those circumstances, I mean, it doesn't sound like he has, as you said, a dependable source of income right now. So a payment plan probably is not the most feasible. How about I put a hold on any future bank garnishments for a period of time? And that way he can hopefully clear up those things he needs to clear up and not have to worry about his bank account being seized.
All right, let's do a hold on bank garnishments for the rest of the year. But it'll be to December 31st. So, Mr. Peters,
if he does have some funds, starts getting some funds and has some monies to work with, he can feel free to touch base with our office and work out some type of payment plan. That's my only suggestion at the present.
all right, this is money they were able to seize. Mr. Peters was not in a very good place in his life at the time this was going down in 2024 and 2025. I would represent that based on my acquaintance with him, he's in way better position today than he was at that point. He's doing a very good job for our court and his probation, but he's got to get some things in order. So I find that the objections are not valid. Mr. Peters, they're going to get to keep this money and apply to this debt. And I will put plaintiff will hold any future bank garnishments until at least January 1, 2027. The bad news is you're not getting any of this money back, but it goes to reduce the debt. You had a Home Depot credit card. The good news is they aren't going to be able to do any further garnishments for the rest of the year. So you can put money in that account, pay a bill, do the things you need to do.
Okay.
But in the meantime, they're going to keep the money, but no further garnishments. He's holding hope that they'll get this disability case resolved, and that would give him some income he could use to pay on this debt. All right. I'll send you a copy of that order. We use the 420 Walnut Street address.
Okay, thank you.
All right, and I'm glad I don't mind seeing you live, but I'm glad you're able to do Zoom. So maybe this means I won't see as much, but somebody helped you do it.
I'm still gonna be there every other week.
All right, I'll see you then.
All
Thanks.
right.
He's been riding his bike to court for every court appearance from Three Rivers, which is about 9 miles. And, but he's very diligent about it. But anyway, thank you for your solution here. That'll get us through a little bit, but, the bank, will remit the funds to the plaintiff.
Good enough, Your Honor. Appreciate it.
All right, thank you. It is 10:30, which is the time for Village Manor versus Boyd. Mr. Butchart is still here. Lori is still here. Meg is still here, and Andrea Boyd is here. And so let's talk about this case. It's actually 10:33. We're about 3 minutes late. All right. This was a case we heard last on June 26th. It was filed as a demand for non-payment of rent. There was a very substantial alleged arrearage, 10,000 plus. The defendant was applying for a recertification, and there were some issues regarding that. Mr. Butchart, what's the status here today?
Well, Judge, Miss Boyd and I, actually, my phone was ringing as I was finishing my last case with you. It was Miss Boyd returning a phone call I had placed to her earlier this morning, and we did have an opportunity to speak just a few moments ago. It's my understanding that she does intend to vacate the property. We've agreed on a date of August the 7th for her to do so. So I can a proposed consent judgment if we need for possession only for the arrearage to be paid or for her to vacate by that August 7th date.
All right. So we would do a conditional order of dismissal under those terms?
I can do it with a CD, Judge, certainly. I did not speak with Ms. Boyd about what that is or what the difference between that and a judgment is. So we may need to have some discussion this morning about that, but I'm certainly happy to do so.
All right, well, let's talk about that. What is the arrearage at this point?
Judge, including July rent, we're showing a balance of $11,961.90. We have court costs of $201.62 for a total of $12,163.52. And Judge, I guess I would also say, yeah, if there's disagreement about those amounts, because we were only seeking possession in this file, as long as we've got a move out date, if she doesn't intend to redeem and stay in the property, I could just do a conditional dismissal, just simply setting them up.
Well, that's since at this point they're not asking for money damages. They're asking you to pay the rent or move, and you intend to move. So they aren't suing you for money. The number we're using is their number, which is $11,961. So you're not going to be able to pay that. So let's say we had an argument about it and I cut it to $6,000. You still probably aren't going to pay that. So you're agreeing to vacate by August 7th. The date we would use from today would be July 20th. You'd have 10 days from today to vacate or pay the rent. So they've agreed to give you an additional 17 days beyond that to August 7th. They're not asking for money damages at this point. Once you move out, you need to turn in the keys and give your forwarding address in writing within 4 days of your moving. And that may be the end of it. If they're going to ask for money damages, we'll have a hearing. People will be placed under oath, will take testimony about what the rent was. Was there a security deposit? Should there have been a recertification at some point? Was there other damage? Was there a broken mirror? Were the cabinets damaged? Was the carpet needing to be replaced? Those are things we could determine at a damage hearing. But at this point, Mr. Bouchard indicates that you just agree that you will move by August 7th. And he's prepared to present what's called a conditional order of dismissal, saying that if you move by August 7th, the case will be dismissed. It won't go on your record as a termination of tenancy. It'll show as a dismissal. If you pay the rent, you get to stay there, but you don't intend to pay it. Excuse me. I'm mining for something that I can't seem to find. Do you understand?
I do.
And you agree to move by August 7th?
Yes.
Do you know where you're moving to?
I'm still figuring that out. But
All
I
right,
want
now,
to get
yeah,
through
you
this
need-
first.
Need to give your forwarding address in writing and turn in the key.
Yeah.
All right, so we're going to use that number, 11,961, 201.62 in costs, and Mr. Bouchard will present a conditional order of dismissal. Ms. Boyd, do we have your permission to put your signature on there acknowledging that you agreed to this
Yes.
term on the? All right, thank you.
You're welcome.
Stay in contact with your manager, Lori, and let her know what your plans are. If you don't vacate by August 7th, they can ask for a writ of eviction and have the sheriff put you out. That's not good.
No.
All right, do you have any questions?
No, I don't.
All right, you're good to go.
Okay, thank you.
Thank you, Your Honor. We'll get that prepared and over to the court shortly.
All right, I'm still not sure how that got so big. And maybe there's a story we'd have to dig into, but I appreciate your working with her. And at this point, when you get that far behind, there really isn't a very good solution except to move and start over.
Yeah, yeah. All right, well, we'll get it prepared and we'll get it over to the court here, hopefully before the morning is over.
All right, thank you very much.
Thank you very much, Your Honor. Take care.
Thank you.
All right, Meg, our next case is not for 20 minutes. So I'm gonna shut off the record. I'm gonna leave the live stream on. We'll have a little dead air. See if we can find a cinnamon muffin or something. And we'll be back at 11 on that matter.
Sounds good, Judge. Thanks for the update. Feel free to bring me back a cinnamon muffin.
Well, I haven't located one yet, but okay, if I
If you
find
find
two.
one. If you find two, that's right, yeah.
Okay. All right, we'll be back shortly, cinnamon muffin or no. Bodacious cowboys such as your friend will never be welcome here.
Morning.
Good morning. Ms. Bauer's in the waiting room. She's here with us. This matter isn't set for about 7 minutes, but you guys are a little early. I didn't know if you wanted to touch base in a breakout or anything before we start?
I'm certainly happy to speak with her. I know that my colleague Dan Landman has been handling this. Unfortunately, he's in the throes of chemo. So
Yes, he's been dealing with us with another difficult case, and we've been watching his progress. We're wishing him well. Meg, could you join us? She might have stepped out.
right?
I left the live stream on and shut the record off. We had about a 20-minute break. Case also.
Okay, thank you.
I've got the whole morning blocked out, the last hour. Anything you guys do to get closer to resolution is probably time well spent. So me and 5,000 viewers are sitting here watching an empty courtroom, but we'll see how long it takes.
Is there really 5,000?
Maybe 2,000.
Wow, that's pretty good.
Yeah, they heard you were coming, and so they.
Yeah, all my fans, right?
You can go on the YouTube channel for this. It's under my name and see, but yeah, it's a strange phenomenon. Colorado, California, Kentucky,
Wow.
Denmark.
Denmark. We're even international then, huh?
Yes, I have people that log in from the Faroe Islands and from New Zealand, and I'm gonna go visit the people in New Zealand, I think, in Melbourne.
Right. Well, those folks are like up probably around midnight.
Well, I don't know. I lose track. I know the California people are here 3 hours ahead of time, and the Colorado people. So I don't know much when you go east or west of the United States what the time zone is. But all right, well, let me put you both in a waiting room while I wait for them.
Okay.
And wait a few more minutes and then just bring them back. So thank you for your patience. All right, I'm going to give them a couple more minutes and then bring them back. As I said, we've got the whole hour blocked out, but if we can resolve this sooner than that. There are some other issues here, have to do with other costs, which aren't readily apparent. So, if they can resolve some of those issues. I'm not sure what that is. It's on the top of the telephone. Got that little screen in the corner of the screen, and I don't know what it is. We'll give them another minute. Everybody's back.
I wanted to make sure they weren't back, Judge. They're not.
They are back.
Okay.
And let me bring them back.
I will wait until he's back, but I have a question that might need some looking into.
All right. Well, we've been on the record, and let's go back. The wireds are in the conference room. I guess, all right, we'll leave you right there for now in case we need to go back to this. We're turning to Centerville Mobile Home Park versus Roger and Ray Wired. They're here at the courthouse. They've been in a conference room discussing matters with Meg Bauer from Legal Aid. The owner of the park, Christy DeCenzo, is here, as well as John Capitan on behalf of the park. This was filed as a termination of tenancy for the expiration of the lease for this mobile home in the park. Not just cause, just that the lease was up in April. And then we've been arguing about whether you're able to do that or not in a mobile home case. There's no just cause, there's simply the lease is up. Defendants have been paying their escrow payments each month, and they're current, and the court is holding that escrow funds. There were some other ancillary issues about other payments or other costs that might not have been readily apparent. As I indicated, this is not a non-payment of rent case, it's a termination of tenancy case. Ms. Bauer, you indicated you may have a question.
Yes, thank you, Judge. I emailed Attorney Landman after the previous hearing, asking if he could have his clients provide a verification of continued residency, because my clients needed that with the post office in order to continue to get their mail. I never got anything back. I understand Dan's and Attorney Landman's had stuff going on, so I'm not blaming him or putting anything on him on that. But I confirmed with my clients again today that had we not emailed them the notice to appear for today, they would not have gotten it. They did not get anything from the courthouse in their mail about this hearing. And so I'm wondering, I know the staff always sends those out. I don't know if they were returned as undeliverable or not. That's what
I
I'm
don't
wondering.
see them. I don't see them in the file, but I'm glad they're here. I'm glad you provided additional notice, but they aren't the only tenants that have had trouble with the mail. Centerville has a limited delivery, and they also have post office boxes in the courthouse, and they're very busy. Everybody in town's got a post office box. At any rate, well, let's talk about this case, Mr. Capitan. I don't think you can do what you're asking to do. There are two statutes that say you can't do a termination of tenancy for the expiration of a lease. You need just cause. So where are we here today?
Well, Your Honor, I think that there's a misunderstanding as to MCL 600.5775, which is the just cause termination statute in Chapter 57A. And its applicability to folks that rent mobile homes at mobile home sites, as opposed to those that, there's some feedback here, as opposed to folks that own mobile homes at those mobile home sites. And I think it's partially due to the fact that Chapter 57A fails to define who a tenant is in a mobile home park or tenancy. But then again, that's why we're here, because Michigan courts have long held that it's a duty of the courts to construe the language of the statute. In construing a statute, courts are required to give effect to the legislature's intent. So that legislative intent has to be gleaned from the statutory text if the language is unambiguous. But when a statute's language is ambiguous, and that's when reasonable minds can differ as to its meaning, and I think that you're reasonable, Ms. Bauer's reasonable, and so am I, and I think that we all have differing opinions. So I think that it's ambiguous, and statutes are generally held to be ambiguous when either one word in the statute has an unclear meaning, or when the statute's interaction with another statute has rendered its meaning unclear. And finally, when an application of the statute to the facts has rendered the correct application of the statute uncertain, like we have in this case. So when it's ambiguous, judicial construction is necessary. And in that vein, the Michigan Supreme Court has instructed that while individual words or phrases, and this is important in this case because we have individual words and phrases, while they're important, they should be read in context of the entire legislative scheme. And to that end, court has to consider both the plain meaning of those words and also phrases and placement, purpose, and it has to be read in conjunction with other relevant statutes to ensure that the legislative intent is correctly ascertained. So turning to this case, we look at Chapter 757A as a whole. And I think that that's where the court needs to first start, is looking at Chapter 57A as a whole, and not just the just cause statute 5775 by itself. And I think when it does that, the legislature's intent becomes clear that that Chapter 57A is solely with respect to owners of mobile homes and not those that just merely rent those homes. And here, I'm going to go into some examples. So if we look at, I think 600.5781. So that's right after, that's after the termination has occurred, and that refers to the sale of the mobile home on site. So it says, Section 5781, if a tenancy in a mobile home park is terminated for just cause, the tenant may sell his or her mobile home on site as provided in sections 21HA, et cetera, et cetera. So someone who is renting a mobile home, well, that just makes no sense because they can't sell the home that they don't own. Also, if you take a look at the section immediately following that, 5783, and that has to do with the judgment for possession. So with the just cause termination, every judgment of possession resulting from an action to terminate a tenancy shall, and this says shall, and it doesn't say may, it says shall set forth the right of a tenant to sell the mobile home on site, the conditions of the right, and the consequences of the tenant's failure to meet those conditions. That again doesn't make sense if it's only referring to someone who is renting the mobile home instead of those that actually own the mobile home. And I think it's also important, and the Michigan Supreme Court has also stated that a court has to take a look at the entire scheme or laws related to not just that section, but other sections as well. And here we should take a look at the Summary Proceeding Act. We should take a look at the definitions under MCL 500-701. Which is the Summary Proceeding Act. And in that case, definitions under premises, it includes structures, fixed or mobile, and also it includes mobile trailer homes. Okay, well, back in those days, they called mobile homes mobile trailer homes, but it includes that. So again, we have a different terminology. But the Summary Proceeding Act is meant to encompass manufactured homes. So, the Michigan Supreme Court says that a court has to harmonize everything to have it provide or give forth the legislative intent, which was meant to encompass. So, this is also a very important thing I'd like to point out is that when Chapter 57A was enacted, the legislative intent is readily discerned by the Senate Fiscal Agency's analysis of the act, and that was completed on October 4th of 1988. And there, the Senate Fiscal Agency explained the rationale for the adoption of the act, and I'd like to put that on the record, and that is that mobile home park tenants long complained that Michigan law treats those who own their mobile home but rent space in a park in the same way it treats other tenants, when, in fact, mobile home tenants tenants is considerably different. Tenants in apartment building, for example, who receive a 30-day eviction notice have 30 days to pack their belongings, find another apartment, and relocate. Mobile homeowners, owners, on the other hand, must either move their mobile home to another park or attempt to sell the home in the park they are being evicted from. Although administrative rules governing mobile home parks require that tenants be offered a minimum 1-year lease, the rules do not require leases to be renewed. Also, many tenants apparently do not exercise the right to a year's lease. As a result, whether a lease is renewed or not accepted, the park owner can give a 30-day notice to quit without cause. So they were just giving those that own manufactured homes this additional protection, which is that it has to be just cause. They were not giving those that rent the mobile home in a manufactured home park, because those are the same as tenants within apartment buildings. They have 30 days to pack their belongings. They don't have to worry about selling the mobile home, moving the mobile home within 30 days. Which a lot of times, I believe back in those days, sometimes, it affected those with lower incomes, the elderly, because they didn't have the funds or means to readily move their mobile homes from the manufactured home community. And I think, some park owners, unscrupulous park owners, would take advantage of that and allow them to leave and take over the mobile home. So, I think that the intent of the act was clearly to protect the financial ownership interests of mobile homeowners. And I think here, contrary to the rationale of the act, the defendant wants the court to hold that any tenancy of a mobile home requires just cause. And I think that basically flies in the face of not only the legislative intent, but looking at the statute as a whole and harmonizing it with the entire Summary Proceeding Act. With that, we ask that this court to construe the act consistent with the intent and grant judgment in my client's favor.
That was very impressive. You've done a deep dive, very deep dive into this act.
Judge, I'm prepared to respond to each one of the points my colleague has raised.
I'm ruling in your favor.
Can I make a brief record? Because I suspect this might get appealed.
Yes, I'm expecting it will also. I'll give you a chance to speak.
Thank you.
I've never encountered this issue in 24 years. The court has always treated a lot and trailer as like an apartment. I see other courts have wrestled with this issue, and it really boils down to the definition of what is a tenant. This law was drafted in 1961. The world's a lot different than it was then. I suspect there were very few cases where people rented the trailer and the lot in 1961. I think people owned their own trailer, mobile home, manufactured home. As you know, they're working on updating this legislation. There are all kinds of problems that district judges are wrestling with. The whole issue of non-payment of rent as opposed to just cause terminations and others. There is no clear answer. And I don't believe there's a clear answer to this, although you make a compelling argument, I think, which would be up to a court hearing this on appeal. All right, Mr. Kaptein has done an eloquent job of stating his position, which requires some serious scrutiny of the entire act and other acts, and he has even looked into the legislative intent. Someone in 1988 is trying to determine what the legislative intent was in 1961. Ms. Bauer, what's the defendant's response?
Thank you, Judge. I'm going to address my colleagues' issues in reverse order, of which they were raised. Referencing the 1988 Senate fiscal analysis makes clear that the Senate understands the words mobile home owners. And the statute that the legislature has in place currently does not use the words mobile home owners in the just cause section or in the summary proceedings section relevant to mobile homes. Entering the arena of legislative intent is not proper when the language is clear on its face. But even doing so, it is clear that if the legislative will existed to change the statute, the legislature would have made a distinction of mobile home owners. They've demonstrated that they understand that distinction. Nevertheless, legislative intent is not appropriate in this analysis because the language is clear on its face. Also not appropriate is the need to look through the rest of the statute, but as my colleague has, let's do that. My colleague references MCL 600.5781 and 5783. 5781 says that a tenant may sell their home on site. Well, it certainly doesn't compel tenants who are renting the home to sell the home. That would be illogical, of course, right? And the statute doesn't use binding language. The statute says the tenant may sell the home on site. Not all tenants, etc. But he says, well, hold on a second. MCL 5783 says that a judgment shall set forth the right to sell. But he's got to keep reading because it also says that the judgment shall set forth the conditions of that right. And certainly one condition of the right to sell the home is ownership of the home. So the use of the word shall to in this sentence to contort the statute into saying that it was only written for tenants who own their mobile home is to read into the statute things that aren't there. My colleague also says that Summary Proceedings Act provides for mobile homes and those tenancies, and I completely agree with him. But he needs to look at MCL 600.5714, subparagraph 3. There, Summary Proceedings Act says a tenant of a mobile home park is not considered to be holding over under the other sections of the statute unless tenancy or lease agreement is terminated for just cause pursuant to Chapter 57A. Here is very clear that the Summary Proceedings Act, the act providing this court with the authority to proceed, contemplates all tenancies of a mobile home park. Now, we don't need to look at the rest of the statute if a statute is clear on its face. I submit that the statute is clear on its face and no further analysis is required. But if further analysis is going to be undertaken, the court cannot insert an interpretation that adds confusion and ambiguity to the effect of the law. So to that end, as relevant perhaps in this case, essentially two questions or avenues of thought. When or how does one draw a distinction between owner of a mobile home park and a tenant of a home in a mobile home park, are we talking about the time at which title transfers? Or are we talking about when someone enters a lease with an option to purchase? Title certainly hasn't transferred there, and yet it is a more permanent form of home ownership. This is a different type of tenancy for sure, but it is a tenancy nonetheless. And so then that leads me to my second question, which is, if Mr. and Mrs. Wired are not tenants in this mobile home park, then what are they? They are tenants in this mobile home park. Therefore, their tenancy cannot be terminated without just cause. Thank you, Your Honor.
All right, thank you.
Can I reply?
Yes.
Because there are certain things that council wants me to look at. Well, first of all, the Senate fiscal analysis has many different words for mobile homeowners. It says mobile homeowners, mobile home residents, and then it goes into residence itself. So there's many different ways that the Senate fiscal analysis actually stated who a mobile home owner is.
Well, let me speak to this. I'm much less impressed with Senate physical analysis than I am with a court opinion or the statute. But I'll let you go ahead and continue.
Right, and with respect to the statute, the interpretation of the statute is to insert that those who are a mobile home renter is meant to encompass section 600-5781, because it says the tenant may sell his or her mobile home. It doesn't say the mobile home owner may sell his or her home. It says the tenant. So if we take that in the context of it encompasses both renters and owners, then we take a look at section 5714 of the Summary Proceeding Act, and it says a tenant of a mobile home park. So just taking the word tenant to mean simply both renter and owner in both statute, if you harmonize that, it doesn't make sense at all. Because taking tenant to mean both means that both can sell the home. So now if you take a look at chapter 57A, which encompasses the just cause, it encompasses the in-person conference, the payment of rent and other charges, the sale of the mobile home, the judgment of possession. If you take a look at that in the context in which all of these sections are put together, it really only makes sense. It's not illogical. It actually makes more sense than the opposite, that this was only intended for folks that own a mobile home. That's all I have.
All right, thank you. The level of advocacy here is quite high, and I appreciate competent counsel and eloquent argument with focus on the law. As I indicated, I haven't dealt with this issue in 23 and a half years, but others have. And the statute needs to get fixed. We need some guidance. But as the defendant argues, this is in two places in the statute. The whole Summary Proceedings Act, which is Act 236 of 1961, Section 57, states in the act itself, in 600-5714, paragraph 3, as cited by defendant, a tenant of a mobile home park is not considered to be holding over under subsection 1B or C unless the tenancy or lease agreement is terminated for just cause pursuant to 57A. So the Summary Proceedings Act says you can't terminate a mobile home tenancy except for just cause. And there are different rules regarding what is just cause, 3 lates and a 12-month period and other issues. Then we go specifically to the mobile home portion, which is at 600-5775, which also uses the word tenancy. The tenancy of a mobile home park shall not be terminated unless there's just cause for termination. Both of those are plain language statute. These people are tenants of the Centerville Mobile Home Park. They have a tenancy. They're renting the lot and the trailer, and they are tenants. They're not residents. They're not non-mobile home owners. They're tenants. And in 2 sections in the law, in the Summary Proceedings Act and in the mobile home section of that act, it says you can't do it unless you have just cause. The language is plain. Some other judges have wrestled with this issue, including my colleague, Sarah Smolinski, in Grand Rapids, who came to the same conclusion I did. All right, the motion to terminate tenancy is denied. No just cause is established or even pled. Case is dismissed.
What about the
Yes.
$7,000 they owe me?
All right, Mr. Senzo, I didn't ask you to say anything, but I'm going to release all the escrow funds to the plaintiff. So the court has I think $3,030 in escrow. That's going to go to the park. If you want to terminate their tenancy for just cause, which includes 3 lates in a 12-month period, you can do that. The law is not clear. Other judges, they cited 2 that ruled exactly the same way I did. Mr. Captain makes a very eloquent argument, but the plain language says you can't do it. So Meg, I'm going to ask you to do an order denying the motion to terminate the tenancy, dismissing the case without prejudice, and releasing the escrow funds to the plaintiff. Mr. Senzo, the rent that the defendants have paid to the court for the last 3 months, I think maybe it's only 2. Maybe it's, I thought it was June, July, and August. I mean, June and July. So I may only have 2 months. They pay, this was June. They paid June and July. So I have $2,200, which will be released to the plaintiff. If you wish to restart this as another type of case, nothing prohibits you from doing that. But this case, for expiration of the lease, is dismissed. All right, thank you. We'll be in recess.
Your Honor, may I review the order before it's submitted to?
Yes.
I was just going to ask for your email address so that we would attempt to submit a stipulated order. Obviously, if we can't stipulate, I'll submit it under the 7-day.
Right, yeah, I'm not difficult. I'll approve it as to form if it has everything Your Honor says.
One of the problems, Mr. Senzo, is these cases they rarely get appealed. I've been cited a couple of cases, one from a district court, one from a circuit court, but they don't get appealed to the Court of Appeals or the Supreme Court. So we don't have a decision from an appellate court that gives us the answer to this question. And other judges around the state are asking the same question. I've ruled that the language of the statute was clear on its face and you can't do this. Other people may disagree. Also, the legislature is doing a major overhaul of the mobile home law, which has been needed for 50 years or more. That may give some guidance to judges on this issue in the future. But right now, that's my view on things. All right, Ms. Bauer will send the order to Mr. Capitaine and I'll sign it when you both approve it. Thank you.
All right, thank you, Your Honor.
Mrs. Wired, you're free to go.
Thank you. And have a good weekend.
All right, thank you.
Thank you, Judge.
All right, that was an interesting case that was well argued by the attorneys, but I think the meaning of the statute is clear on its face. They have other ways to do it. They just can't do it that way. All right, that finishes our day, our week. And we'll be back intermittently in the next 10.
Can a family court judge repair a broken relationship between parents and children when years of conflict have already driven them apart? That difficult question was at the center of this emotional courtroom hearing. A mother returned to court claiming that despite an earlier court order, she had been denied the parenting time she was legally entitled to. She told the judge that she had gone nearly 3 months without seeing her younger children, even after a referee had ordered make-up parenting time. According to her testimony, communication with the children's father had completely broken down. She said he ignored her messages, failed to tell her about counseling appointments and school activities, and left her feeling completely shut out of her children's lives. The hearing quickly became about much more than missed visitation. It became about rebuilding trust in a family that had fallen apart. The father acknowledged that the current parenting arrangement had been difficult, but explained that the children were already receiving weekly counseling. He testified that after the children began living with him, he believed they needed professional help to cope with everything they had experienced. The judge listened carefully to both parents before explaining an important difference many people don't realize. She said that a child's individual therapist has a responsibility to protect the child's privacy and build trust, meaning those counseling sessions are different from family therapy, where parents and children work together to repair their relationship. Rather than forcing the children's personal counselor into that role, the judge explained that an independent family therapist would be more appropriate. Both parents agreed that counseling could help, making it one of the few points on which they actually found common ground. The judge then shifted the conversation away from blame and toward solutions. She encouraged the mother to contact the children's counselors, not to demand confidential information, but simply to let them know she wanted to participate whenever appropriate. She also reminded both parents that because they shared legal custody, communication had to improve. The judge discussed practical issues like insurance coverage, treatment costs, and finding a counselor who accepted the children's health plan. She even recommended using a court-approved communication app designed specifically for co-parenting disputes. If that wasn't affordable, she suggested creating a separate email account used only for communication about the children. The message was clear. Successful co-parenting requires organization, transparency, and respectful